Someone will give a countdown. Good afternoon and welcome back for part 2 of Lakeshore Legal Aid's 3-part education advocacy series. My name is Courtney Marshall. I'm a community engagement coordinator with Lakeshore and I will be your monitor this afternoon. Whether you're returning from part 1 or new to our series, thank you for joining us. We're glad you're here. Today our presenters will be talking about school discipline and how it relates to both general and special education students, but with a primary focus on discipline and special education. I'd like to introduce our presenters, Antoinette Williams-Dial, staff attorney with our Counsel and Advocacy Law Line, also referred to as our call line, and Susan Marquardt, supervising attorney on call. Thank you both for being here and for presenting for our live audience once again. The presentation this afternoon will last about 30 minutes, followed by a question and answer session. If you have a question for our presenters, please put it in the chat to be addressed during the Q&A portion of the presentation. We're excited to jump into the material today, so without further ado, I will turn it over to our presenters. Antoinette and Susan, take it away.
Thank you, Courtney, for that wonderful introduction. Hello, everyone. Welcome. Thank you for those who are returning. Thank you for coming back to view our Facebook Live session on school discipline. And for those who this is your first time tuning in, this is the second installation in our 3-part series on special education education advocacy. So today we are going to talk about discipline basics and student rights, and also suspension and expulsion and the difference between the two.
We're going to spend some time also talking about what you can do when you cannot reach consensus and resolve your dispute with a school, when there's some concerns about a way your child's being disciplined, and where you go when you have really exhausted your options there, and who you can file a complaint with. We're going to talk about some things you can do to avoid having to go into litigation with discipline matters, and even more proactively what you can do to head off discipline issues in the first place. And then we'll follow up by sharing with you some resources that we rely on in our work as legal aid attorneys, and things that we found to be helpful in our quest for knowledge where special education law is concerned that we think you might find to be helpful as well. To start, we just wanted to, let me back up even further. So when we thought about what we might like to talk about for this second presentation, we do get a fair amount of calls, education calls at the Counsel and Advocacy Law Line on discipline matters, and we do find that there's oftentimes a connection with discipline issues, that oftentimes kids that are receiving frequent or repetitive disciplines also may have some special education needs. So it was natural from that standpoint. We also know that discipline issues can affect kids, all children, but can have really a snowball effect on the entire family. When a child gets called, when you get that call to come pick up your child, you may have to leave your work. If your child ends up being disciplined for a more extended period, you may have to take time off from work, more extended time off from work. We do know from the calls we get, sometimes it leads to a parent losing a job, which can spiral in a number of other ways that are not so good, including affecting their housing and ultimately putting them in the crosshairs of Child Protective Services if a child becomes homeless as a result of all these things that have snowballed. But we, to start, wanted to share this quote with you to kind of, shed some light on the state of affairs in our state. This comes to us from Michigan Poverty Solutions. This is an organization out of the University of Michigan that has done some research, most recently showing the connections between homelessness and discipline rates. Michigan thrives when its children thrive. While policymakers, educators, and families all know this to be true, widespread use of suspension by the state's public schools is leaving lasting scars on our students. Compared to other states, Michigan schools have some of the highest rates of suspension in the country. This is not a top 10 list we want to find ourselves on.
Not to say that, this should put a cloud over parents and families regarding school discipline. The issue with Michigan is that our schools use a punitive disciplinary process rather than rehabilitative or restorative disciplinary processes. Kids are kids. They're going to make mistakes. They're going to do things, and they don't always understand what they did wrong or why their actions were inappropriate. So a lot of times it's up to parents to advocate for less punitive disciplinary actions so that the child understands that you're going to be disciplined for this action, but let's do it in such a way that doesn't cause damage to the child as well.
So just an outline of what is school discipline. There have been some new things that have come into the picture in more recent years. You know, you start with detention. The child is forced to spend some time in a room with a grumpy administrator. At least that's what the movies would have you believe. I remember the movie Breakfast Club.
Yeah.
Yep. And, that was all about kids in school detention, so really common. And then the next step would be a suspension. That's where the child's removed from the classroom for a half a day or a full day or multiple days. Today, schools will consider sometimes doing in-school suspensions where the child is not participating in any way but must remain in the school. Antoinette, I know, has some comments she's going to add on that in just a few minutes. Discipline can also include exclusion from special events. We always start to get these calls on our hotline at this time of year as we get closer to the end of the school year. Kids get a little rowdy, and they get in trouble. They're not allowed to go to prom, or maybe there's some issue with them being able to walk on graduation day, and that always creates a lot of stress and leads to some calls to us. And then the most extreme is expulsion, where a child is told they must leave the school, and it's termed, they use the words permanent expulsion, but we'll talk about just how permanent that really is a little bit later.
And for in-school and out-of-school suspensions, in-school suspension may sound a little foreign to some parents because they didn't always do that when we were younger, but some districts do in-school suspension because parents preferred that because they don't have to take time off work because their child's been suspended from school. And other schools don't use in-school suspensions because they don't want their children singled out, so that everybody knows, well, you've been suspended from class because you did something wrong. Now, there are a number of common disciplinary issues that we see. Some of them you may be familiar with because we had to deal with those same issues as kids, but there are some new disciplinary issues that have arisen because of the changes in the world and technology. So some common disciplinary issues are fighting. Everyone's aware what that is. Insubordination, and examples of insubordination are child's not listening to the teacher, talking back to the teacher or school staff, not following directions given by school staff or teachers, not following school rules. There's also issues with weapons in school. Those are treated very seriously. Child sent home for having a bad day. Everybody knows Alexander's horrible, terrible, no good, bad day. Well, sometimes a kid can get up and not be having a very good day and goes to school and he's not making good decisions and he's being a little disruptive in class, and they may make the decision to send him home before the issues snowball into something more severe disciplinary issue. So he gets sent home for half of the day. And then there's also video recording at school. When we were in school, there were no cell phones. Cell phone was about as big as your hand, big as your head. Nowadays, most kids, generally between 2nd grade to 12th grade, have a cell phone, and that cell phone is a computer. And so they can get in trouble for taking pictures and posting them on social media of other students, posting videos of themselves and other students on social media. So got to be careful with those cell phones.
I just saw an article, I didn't take the time to read the full thing, but the headline was that's kind of a trend with schools starting to actually make kids check their phones at the door and not have them throughout the day, which I thought that's a whole nother Facebook Live discussion, but that was just an interesting thing I saw just this week.
Now, the legal basis for school discipline, it's twofold. In Michigan schools, school discipline is kind of built on a contract, and the contract is built around the school code of conduct and the statutory framework. So, first part of school discipline is state law. Michigan state law requires schools to handle disciplinary issues. Second part is the school code of conduct, and the school code of conduct basically lays out what actions will cause disciplinary reaction and what the disciplinary process is.
When we get calls on our hotline asking parents what their school code of conduct is, usually one of the very first parts of our discussion, and it is a really important document that really outlines a lot of what should be happening in the discipline process. So let's talk a little bit about what rights are out there for kids that are getting in trouble, and we'll talk more generally about suspension and expulsion, since those are the higher impact forms of discipline. First of all, one of the things I was really interested to learn as I started to get into this area of work is that notice doesn't have to be in writing. It can be oral. So your kid can be expelled from or suspended or expelled, and the notice does not have to be written. They're entitled to a form of due process in that they're supposed to be given notice of the allegations that have been made against them, what kind of evidence is being relied upon in those allegations. They're supposed to have access to that same evidence. What is the proposed form of discipline? It's not supposed to be indefinite. It's supposed to be discrete and identified. And they're supposed to be given notice of their right to respond if they disagree with the allegations. Ideally, the student should be given notice, or the family should be given notice before the student is removed from schools, but schools do have a right to remove a student first and then provide notice later if there's some concern to the safety or well-being of the student population or to the facility itself. Parents should be receiving notification. There is a there should be a quick hearing in the matter. You shouldn't be waiting unreasonably long periods of time for that to play out, because that's a very serious thing when your child is removed from school, which is something they're entitled to. And there are some constitutionally protected due process rights that are laid out in a Supreme Court case called Goss v. Lopez, for any of you interested in looking up that information. So when kids are suspended for 10 days or over 10 days and or being expelled, there are some additional considerations that the school is supposed to be working through. First of all, there is a presumption that it's in the best interest for the child to remain in school, and the school has an obligation when bringing these more severe disciplinary actions to overcome that presumption that it really is in the best interest of the school overall, more so that this child be disciplined and removed from school. The school is supposed to go through these 7 different factors that are laid out here in this slide. They're supposed to look at the age of the child. We know that discipline oftentimes is physical discipline is treated a little differently for younger kids versus older kids. They're supposed to look at the history of discipline. They're supposed to look at disability. This is something we talk quite a bit about with our calls at the hotline, because we oftentimes do see that connection, as I mentioned a little bit earlier. Is there some kind of 504 plan in place for the student? Is there an IEP in place? Those are documents that lay out special supports or accommodations the student should be receiving. Was the school following through on that leading up to the discipline? They look at the seriousness of the violation. Was there any threat to safety? Is there some kind of restorative practice that might be available? An example of restorative practice would be peer mediation. We see a lot of schools starting to offer that, where they have basically they'll identify student leaders, and those student leaders receive some special training in how to help students work through disputes or behavioral issues, and helping them accept accountability where that's appropriate, and maybe come up with a lesser punitive form of discipline. Thank you. And then lesser interventions. A good example of a lesser intervention where suspension may have been an option. I'm sure there's a lot of stories out there like this, but I remember when a couple of my kids were going through school during the end of the school year, there was a senior prank that involved the kids showing up with watermelons. Every kid came to school with a watermelon, or many kids came to school with watermelons, and they set them down in the main hallway. So you can imagine, whatever, several dozen or 50 kids showing up with their watermelons and placing them in the middle of the main hallway. This was really disruptive. Of course, it got a lot of laughs. And I suppose there was probably an opportunity for someone to be suspended for that, or maybe more than one person to be suspended. But a lesser intervention may have been just to have those kids come in and clean up the mess. They were checked out. It was the end of the school year. So yeah, they're supposed to consider lesser interventions. Now, there is no requirement when schools are going through this evaluation of these 7 factors that this be put in writing at all. It's just a requirement that they're supposed to consider each of these things.
Now, students who receive special education services, there's an additional level of protection built in for those students regarding suspension and expulsion. So if the student is going to be suspended or expelled for more than 10 days, and it doesn't have to be 10 consecutive days, it can be 10 cumulative days throughout the school year, there has to be a manifestation determination review hearing, MDR hearing. And in that hearing, the school has to look at, is the discipline issue related to the child's disability? And was the school in compliance with the child's IEP or behavioral intervention plan at the time the disciplinary issue happened? During the MDR hearing process, the student has to basically stay put in their educational placement, so they can't be moved out of, they're in the general education classroom for part of the day, they can't be required to be in special education for a full day. So the MDR hearing, the right to an MDR hearing applies to students with IEPs. A student with a 504 plan isn't guaranteed a right to an MDR hearing. Sometimes schools will conduct one if the child has a 504 plan, but it's not required. And then special education students who are expelled or suspended long-term, the district has to continue to provide them with educational services. They can't stop services because the child was expelled.
Let me just add one thing too on the stay put piece of it. It can involve that interim period can be in school suspension. So it's not necessarily that your child with special education with special education supports is necessarily in the same classroom doing the same things while this all plays out. It could be that their stay put involves in school suspension.
Now, for when we are talking about permanent expulsion, that's where a student is expelled from the school district permanently. The student is not able to enroll in any other public school district in the state of Michigan unless they have been reinstated. So they can be placed in an alternative education program. Not every district has one. Some districts do. A lot of the larger districts may provide alternative education programs for students who have been expelled or suspended long term. And Michigan law does require school districts to permanently expel a student who possesses a dangerous weapon. So a gun or a knife can be considered a dangerous weapon even if it's not a real gun. The student commits arson or criminal sexual conduct, so sexually assaulting another student or staff or faculty member, and also assault on a school employee, volunteer, or contractor. So the important thing to note is with these issues, not only are you looking at school discipline and potential expulsion, but you could also be looking at criminal prosecution in the juvenile justice system.
One thing too, just a side comment. I took the time I was just curious, like how many alternative education programs are out there, and the state of Michigan Department of Education does retain a list that's available to the public on alternative schools. And it was a spreadsheet that had something like 500 entries on it, but it wasn't 500 different alternative schools. I think it was probably closer to maybe half that. But anyways, if you're interested, hopefully you're not in that position, but if you are needing to look at alternative education programs, the state, I think it was under school safety maybe, on the Department of Education's website.
And they probably included boot camps as part of that as well.
Yes, yeah, and that is a form of alternative education the school can offer too. So if your child has been permanently expelled, I was really happy to learn as I got into this area of law that permanent doesn't really mean permanent hopefully for most students, if not all. There is an opportunity to petition for reinstatement. That petition for reinstatement must be submitted by the parent or guardian, or it can be also submitted by the student if the student's 18 years of age or older. The school has no obligation to help you prepare that petition in any way. There is varying timelines as terms of when that can be, how that process plays out. But in general, you would be filing a petition no sooner than 150 days after the date of expulsion, and the reinstatement itself, meaning the child returning to the school, could not happen any sooner than 180 days. So you're looking at a 6-month time period. Your child's out of school. You're needing to find a private school or homeschooling options if there's no alternative school available for them. So within 10 days of getting that petition for reinstatement, the school board has to put together a committee to review the request for reinstatement, and then from that 10 more days they must they must hear the matter and submit their decision on the request for reinstatement.
So expulsion doesn't mean permanently removed from the school district. It means permanent with the option to come back.
Right, right. And I forgot to mention too, one other thing, the request for reinstatement can be at the same school your child was expelled from, but it would also be required if you're going to another school in the state. You'd still have to seek reinstatement. You would just file it with the new school you're trying to get back into, because the expulsion is statewide.
Now, it would be great if you can resolve the issues with the school at the school level, but sometimes the issue doesn't get resolved at the school level, and so you have to go to the next level. So you can file for students who are in general education. If you can't come to a resolution at the school level, you can file a complaint with the school board. That would be the first place to start. If you can't come to a resolution with the school board, then the next level would be to sue in state circuit court. Unfortunately, going through a circuit court case can take a long time. Usually it's about from start to finish 2 to 3 years before you can complete a circuit court case.
And when you get to that level, you're really needing to show some really pretty significant violation of the school's code of conduct on the school's part, or something pretty dramatic that has happened that you hopefully have good evidence of. It's not easy to do on your own. I mean, there are attorneys out there that do that work. Our organization does some of that work, but it's kind of the last place you want to find yourself. But at times is the appropriate place you may find yourself in certain circumstances. So for special education students, the complaint process is a little bit different. There is an opportunity for due process types of complaints. We really should have had a slide on this particular issue, so I'm just going to add that in. There is an opportunity for due process complaints to go through administrative hearings before an administrative law judge. But the process is to file a complaint with the intermediate school district if you're unable to resolve your matter at the school level. And then through the intermediate school district, that can be issues with the teachers or staff, any kind of general grievance you may have with that part of things. This is where you're going to start. Next, you would go to the Michigan Department of Education for your next level of complaint. That's really a complaint regarding the student's civil rights having been violated. This makes sense when you look at the context of the fact that a special education student is protected. Their rights are protected under federal law as a protected class, as individuals with disabilities. Those need to be filed within 1 year of the alleged violation. And then, just like with general ed students, the last place you go, if all else fails, is you're going into state court. And those, a case brought in circuit court can then be appealed to the next levels within the state courts as well. You have to file the state court complaint within 90 days of the Department of Education's decision and order.
And one thing we want to mention about due process complaints, it's not the same as constitutional due process rights. A due process complaint for special education students is a different type of complaint, and it's not supposed to be filed if you have grievances against the schools or the teachers. This is about violation of the students' rights under the IDEA and compliance with federal laws with providing their special education services. So when a child's constitutional rights have been violated, their constitutional rights and civil rights are applied in school settings. So these types of violations can occur with students who are in general education, as well as with students who receive special education services. If you feel your child's civil rights or constitutional rights have been violated, you can file a complaint at the federal level with the Office of Civil Rights for the Federal Department of Education. Now, this department investigates serious complaints such as noncompliance with special education and serious complaints regarding inappropriate behavior by school personnel.
Those complaints, too, would need to be filed within 180 days. And those, again, are generally really related to, violation of civil rights specifically.
we do get a lot of questions from parents about their child being excluded from attending special events with the school. There is no right to participate in special events in the school. So a school can prevent a child from going to prom, homecoming, participating in graduation if the child violates certain rules. So when they tell your senior, hey, if you guys walk out on senior skip day, you can't go to graduation, the school is well within their rights to tell them that. If they tell the kids, hey, no senior pranks, if you get caught pulling a senior prank, you can't go to prom, they can do that. So remind your seniors that just like they were invited to go to something, they can be uninvited just as quickly. Now, if a school prevents your child from going to graduation, they can't withhold their diploma. The kid just can't walk across the stage and have that big moment like the rest of their classmates.
So we wanted to spend a couple of minutes just talking a little bit about some things you can do kind of more on the front end of all this. Now, mediation is something that we think should be explored by more people. This is an option for people in civil cases as well. But it's something that you would use as a resource potentially. Your child is going through discipline measures, you have some grievance or concern about the way it's happening, but you're not yet to the point where you're ready to start filing complaints and going to court. You can consider mediation. Mediation is a nice option in that the goal of mediation is to provide consensus, to have everybody reach some kind of compromise everybody is comfortable with. I mean, at the end of the day, if your child's being expelled, you're still going to come back, or even suspended, you're going to have to come back to the same place unless you're going to leave the school district or leave the state. So really finding a way to more amicably, I don't know if that's the best choice of words, but it's the only way I could think of in the moment here, to come to some consensus about what should happen, it's going to be better. For general education students, it's optional. It's actually optional for everybody, but it's something you would need to pursue or the school would need to pursue, and there may be additional costs. There are some mediation services that are offered out there for people that may qualify from a financial standpoint at low cost, but it's something there is an expense for. But compare that to the expense of hiring an attorney to take a matter into court or to deal with an administrative hearing on a due process violation. It could be well worth it. It's also probably quicker to do things through mediation, so there's that. But with special education students, it's actually built into the process as you go through challenges to discipline issues. There's an entity called Special Education Mediation Services that provides mediators at no charge to the school or the student. It's funded federally, where they will actually identify the mediator and get everything set up. So that's helpful to know.
And one good thing about mediation is it's a less adversarial process, so you have the opportunity to preserve the relationship between the family and the school while resolving the issue.
Yeah, that's a good point. And I forgot to mention, a mediation agreement can be legally enforceable. But with that said, also sometimes we talk to people going through civil matters, even not necessarily education, where they think mediation is something they must reach an agreement, and that's not the case. Mediation is an attempt to come to agreement, and sometimes it happens that you can't. So there's no obligation that if you go through mediation, that's the end of it, and you're stuck with whatever comes out of mediation. So if you can reach an agreement, great. That could be legally enforceable, but you don't have to if you really can't reach agreement. So let's talk, we wanted to kind of, as we start to wind down our main part of our presentation, talking a little bit about some of the things we see when we talk to clients that maybe would have helped them in avoiding or heading off the discipline issues that have kind of exploded and are leading them to reach out and find legal counsel. First of all, kind of basic, but just communication. And I know as a parent, I have 3 kids who are now young adults. I went through the experience of trying to be the involved parent when my kids were in elementary school and doing the class parties and all that when I could. And as you get old, as your kids grow, the schools tend to kind of, put their arms out and say, hey, we don't need you for class parties. The student is responsible for these things now, which is natural for their development. But you still really have to keep your eye on the ball, so to speak, and thinking about ways where you might need to intervene on behalf of your child. So if there's something going on in your home life that's causing some strife or challenges for your child's struggling with mental health issues, physical, or somebody else in the household's having some health issues, maybe there's somebody just lost a job and everybody in the household is concerned about that, or they're being evicted. Those are things, while they're really personal things, it's actually an appropriate thing to reach out and share with your school teacher and school staff to let them know. It may lead them to be more compassionate in understanding where your child's coming from if they're acting out. It may lead them to maybe come up with some creative solutions as to how to help better support your child in the classroom. So really, really encourage you to do that and be proactive about it. Don't wait for the bad thing to happen. Like, think about doing it in the moment.
And another thing you can do is request accommodations if needed. A lot of times we see school discipline issues as a backdoor into special education. The child may be acting out or exhibiting behaviors that because they need special education services. Other times, if there's a death in the family and the child was very close to that family member who died, going through the grief process can be difficult. So let the school know, let the child's teacher know, we had a death in the family, my child's not taking it well, and you can request accommodations for the child. You might need to keep them home for a couple days so they can start the grieving process in peace. You can ask the teacher, look, can I get their schoolwork and their homework assignments so that they can complete them and return them when they return to school, or even ask for an extension on assignment deadlines because of what's going on in the household. Another thing you can do is to create a plan with your child on how to handle escalating issues. So if your child has another child at school that they don't get along with and they keep picking with each other, or there's kids at school who are bullying your child, you want to talk to your child about how to handle these situations, especially with bullying, because you need to have a paper trail, and you don't want your child to end up facing suspension because they were being bullied. They finally got fed up and decided to fight back. Another thing is to know your school code of conduct. Don't have to know it verbatim. You don't need to be able to quote section 5, subparagraph 3 on page 329. You just need to know the basics of what conduct will result in discipline, what the disciplinary process is, and you need to discuss that with your student. And then you need to make sure that when discipline issues arise, the school is following the disciplinary process that they've laid out in the code of conduct. Another thing is talk to your children and have those difficult conversations about social media and being responsible when using their cell phones. It's a computer. They basically have a supercomputer in their hand and they take it with them everywhere they go. So you want to be sure they understand the responsibility of having that computer in their hand and what types of disciplinary issues can arise if they misuse that privilege. So at this point, we're going to open it up for questions. So
thank you,
turn it over
Antoinette
to-
and Susan. Thank you. Sorry to talk over you. This has been such valuable and important information for our audience. I'm sure they're getting a lot out of it. So yeah, we're going to pivot now to the Q&A portion of the presentation. And I don't see that we have any questions in the chat at this time, but I do have some offline questions. First offline question. Does Michigan have early intervention or diversion programs to address disciplinary issues before they escalate?
Well, they don't have any early intervention or diversionary programs. It would be really great if they did, but unfortunately, we don't.
But check with your local school district, because it's entirely possible. There are lots of things going on at the local grassroots level that your school may have some kind of program in place locally, but we're not aware of any statewide efforts in that regard.
Thank you. Next question. Does the school have a duty to suggest to a parent or guardian that a student's behavior, which has resulted in repeated disciplinary action, may be indicative of an unidentified need for special education services, such as an IEP or 504 plan? So in other words, does the school have to raise that with the parent, or is it really the parent's responsibility to raise that with the school?
That's a really good question. Yes, there is an affirmative and ongoing duty that the school has under something called Child Find. that if they identify a student that appears to be in need of additional supports and they have some reasonable belief that they may benefit from special education services, that they are supposed to initiate that process of considering that child for special education services, even if the parent has not.
And there have been cases where the school has approached the parent about special education services because of disciplinary issues. One thing is that the parents have to be open to the idea that their child may need special education services, because they can refuse to have an evaluation done.
Yeah, we do, and we see this is actually a pretty common theme we see in our calls. The other thing, just kind of a general thing to be mindful of, we talked a lot about this in our last presentation, is there is a bias in public school settings to not necessarily be so proactive in coming forward and encouraging students to receive special education supports, because they're federally mandated to do that if a student's identified as having those needs, and the school has to do so. They just must do so. So sometimes what that may require is they have extra staff be provided, or do additional things, and they may not necessarily yet have staff available, or their budget may be tight and they're trying to work through those issues. But at the end of the day, that's really the school's obligation. So schools sometimes aren't as proactive as we like, and we see sometimes there's some opportunities for education advocacy there to remind them of those rights. If their child, we'll get the call where the child's been in trouble repeatedly over time, and they have, and there's very clearly some kind of thing going on with this child in terms of their health, and yet there's no special education support services in place.
Great, thank you for that. We do have a question in the chat. Does a school have a duty to provide a one-on-one parapro if a child's behavior issues are extensive, or if behavior improves when the child has more one-on-one attention? I can repeat that if you need me to.
Yeah, the last part especially.
Sure. Does a school have a duty to provide a one-on-one parapro if a child's behavior issues are extensive, or if behavior improves when the child has more one-on-one attention?
I think the first thing you need to look at is what need is the one-on-one parapro fulfilling for the student. A parapro's role is very important. They are there to help support the student and help them throughout the school day if there are certain things that they need help doing. But when you are requesting a one-on-one parapro because of behavioral issues, you have to identify what need that service is going to fulfill.
And just let me back it up just a little bit, because really before you even get to the point of requesting a parapro, you have already, to be having that conversation, you would have already gone through the process to get an individualized education plan or IEP or a 504 plan for your child. And a school can absolutely be required, and you do see kids that have paraprofessionals that follow them through the day and helping them and supporting them. But to get that level of support, you have to have a reasonable accommodation that has been granted as part of your IEP or 504 plan that dictates that's necessary. And that's, it's a spectrum. There's kids need different levels of support. So, that can evolve too with time. So maybe a child at one point in their education needed a full-time parapro, but as they grow and develop and get services inside and outside of the school, they may not need that extensive level of support, and it is within a school's rights to maybe make adjustments to that. But it's also something, it's on the table to be considered, but it's not like a guaranteed either thing that just because you have an IEP or 504 plan, your child should get a parapro. That would be, our schools just, that's unfortunately not how it's set up today.
And it's all driven by the child's needs.
Yes.
Okay, great. Thank you for that. Pivoting now back to our offline questions and piggybacking somewhat on the question about an unidentified need for special education services. If it turns out that a student's disciplinary record is directly related to that unidentified need, and say that disciplinary record is quite large before the need is identified, can that record be suppressed or expunged once the services are put into place?
Yeah, that's a good question. There's a couple of laws that provide guidance on how student records are controlled. There's something called FERPA, you may have seen in your school's code of conduct, or the many, many papers they send your way, or electronic documents they send your way to sign at the start of the school year. It stands for Family Educational Rights and Privacy Act, and then there's the IDEA. We've referenced that, I think, a little bit earlier. That's a federal law, federal act that's in place for students with disabilities. But it does maintain that you have a right to access your child's record and review that information. The school is not obligated to hand you a nice, neat envelope with all the records in it, but you do have a right to review the file. They can offer to let you make copies. They can charge reasonable fees for letting you make copies of that record. Beyond that, they aren't allowed to share that with other people generally. There are exceptions, of course, if there was some kind of criminal investigation, some kind of court order that those records were needed, that could be overcome. But in general, those records are not allowed to be shared. If you had some concern about a way a discipline matter was handled, one of the pieces of advice that I will give clients when I'm talking to them is you should send a letter to the school, just what your dispute is or what your concerns are, addressing what has happened, and then ask that be added to your child's record as well. So there's a counterbalance to the school discipline piece. There's your response, or maybe it's your child's primary care doctor addressing it, or a therapist, what have you. So it's a record that's out there, but it's not available to the world whenever they want. It's not like it's not a public record for all to see.
Usually when it comes into play is when you're trying to transfer your child to another school or another school district, and they ask for you to provide a copy of your child's disciplinary record, because they want to use that in considering on whether or not they're going to accept your child into their district.
Yeah, that's a good point.
Thank you very much. And at this time, it looks like we've got about time for one more question. And this is kind of a two-parter. How does the education system in Michigan address disparities in disciplinary actions, particularly concerning race, gender, or disability status? And in your experience and professional opinion, do you feel that the Michigan education system is addressing these disparities adequately?
That is a very good question, but it's also a complicated question, which we cannot answer in the time frame we have for this presentation. That would actually be a whole nother presentation in and of itself, and there are a number of research papers out there on these specific issues regarding the disparity with school discipline, looking at race, disability, sexual orientation. So that is a whole nother conversation, and if anyone is interested in having a presentation done on that, please send us a comment. Let us know.
That sounds great. Thank you both very much.
So we're as we wind down here, we want to make sure you see our contact information. Antoinette and I both come from the Council on Advocacy Law Line, which is part of Lakeshore Legal Aid. We are a legal services organization that will provide free legal assistance to folks that qualify. So when you call into our 800 number listed above, we'll spend a few minutes getting some information from you to see if you qualify, and then from there we would provide free over-the-phone legal advice. Anybody who takes the call for the full intake process is a licensed attorney. And then from there, for some of our cases, we are able to refer them over to our local legal aid office within Lakeshore, or some of our partner programs, legal aid offices throughout the state, and potentially getting them further services, maybe at a hearing or with the school, or in other civil matters too. I don't think we even talked about that, but we do provide civil legal services in many, many different areas in addition to education as well. So we're open Monday through Friday. Our hours are listed on this slide. And back to you, Courtney.
Thank
One
you.
second,
Oh,
Courtney.
sorry.
Can we go back to the QR code page? So I just wanted to point out for everyone that if you scan the QR code for education advocacy resources, we have set up a landing page where you will be able to access Michigan law regarding school discipline. So you'll be, if you feel like reading through the laws one Saturday afternoon, you can find the link to those laws on that landing page. There's also resources for parents on filing a complaint, as well as a link to the guide created by the state of Michigan regarding guide to school expulsion and school suspension that clearly lays out the expulsion and suspension process that is supposed to take place in Michigan schools.
Great, thank you. That's a wonderful resource for our viewers. And that will conclude part 2 of our series. I want to thank you again to our presenters, Antoinette and Susan. And thank you to our viewers for joining us today. Great question, by the way. Please watch our Facebook page for the details about part 3 of our education advocacy series coming soon. Enjoy the rest of your afternoon. Thank you.